Hello, everyone. Welcome to our webinar today, the Visa Surcharging and Discount Programs Compliance. I'm Charles Bishotter. I represent Bishotter Law. And with us today, we have Nicole Pilot with Bishotter Law. And we are thrilled to have you guys join us today on this very important education section that we're going to have. We are hosting this webinar in collaboration with Reeve Basnet, which we are very proud to have as our friends and colleagues, because we work very closely together in multiple things. You can find more about our firms and services on our respective websites at www.bishotalaw, that is BISHOTALAW.com, and on www.reevebasnet.com. That is REEVEBASNETT.com. So the objective for this webinar, really, after talking to all our clients, was really to discuss the nuts and bolts of the visa rules and regulations in the world of surcharging and discounting. This topic has been very popular, at least in the last 2-3 quarters of this year, based on several things that are happening in our industry. So we are very excited to have a guest speaker today that can give us more insights and knowledge that will help us to better understand the complexity of surcharging and discounting, and how can we be in compliance with the rules and regulations set forth by Visa. And we do want to pause before we start this webinar today to just mention that our guest speaker is not a lawyer. So we are not going to be covering any questions that could venture into the world of legal advice. If you have any legal questions, you can contact your respective law firms, whether it's Reeve Basnet or it's Bishotter Law or any other of the industry colleagues that you work with. Further, I do want to emphasize that this webinar is for educational purposes only, and nothing we discuss today should be construed as legal advice. We are glad you're here, and we hope you find this session very useful. This webinar is being recorded, and we're going to be making it available after to all the attendees. I'm going to now hand this over to my friend Jay Reeve to introduce our guest speaker. Thank you.
Thank you, Charles. My name is Jay Reeve with Reeve Basnet PLLC, and it is my pleasure to introduce our distinguished speaker for today's webinar, Mr. Robert Johnson. Robert brings a wealth of experience and knowledge from his extensive career in the card payments industry, and particularly with Visa. Robert's been with Visa for over 18 years and is currently serving as the head of Visa Rules Management for North America. In this role, he oversees the largest region by payment volume for Visa, focusing on rules development, compliance enforcement, and ensuring the integrity of Visa transactions. Robert's belief that the happiness of cardholders and merchants drives mutual success is at the core of his work. Robert is known for his commitment to enhancing business success through intelligent use of technology in digital retail. He understands the value of a greater user experience and has a proven track record in this area. With over 30 years in the card payments industry, Robert has developed a deep understanding of the intricacies of payment systems. His previous role as director of EMV contact chip and contactless payments at Visa saw him leading the implementation of business rules for Visa's EMV contact chip and Visa PayWave contactless payment products. Before his current tenure at Visa, Robert was a dispute executive and project manager at Visa Europe, where he honed his skills in payment systems and dispute resolution. Robert's educational background includes his time at Blatchington Mill School and Sixth Form College in Hove in the United Kingdom, where he laid the foundation for his illustrious career. Today, Robert will share his insights and expertise on Visa surcharging and discount programs, drawing from his extensive experience in rules management and compliance. His perspective is obviously invaluable for anyone looking to navigate the complexities of Visa rules and regulations. So please join me in warmly welcoming Robert Johnson to our webinar. Robert?
Thank you, Jay. Thank you, Charles, for a very kind introduction. Yes, so yeah, thank you everyone for being here. Am I sharing the blue screen now? It's one screen has changed, the other one hasn't. Okay, good show. All right, well, look, thank you very much for having me. It's an honor and a pleasure to be here. Since Jay went into my educational background, I won't make the joke about my accent being from California. Obviously, it's not from California. And yes, I'm excited to be here and talk about the visa rules, specifically with a lens to surcharging and cash discount. It is a very popular topic in North America right now, and one that Visa is very keen to ensure we educate properly on. So I do want to start off by advising that the visa rules, I'm going to give an overview of the visa rules. The visa rules are by and large public. There is a somewhat redacted version on visa.com. If you went to visa.com and just type in the word rules, it will take you to a link where you can download the latest edition of the visa rules. As I say, it is a redacted version, but it's only redacted about 2%, and they are minor security details. If in relation to things like surcharging and discount offers, there's no redactions of those rules. So they are very visible. As well as that, on visa.com, there is a section near the visa rules that talks about surcharging. And we have a number of documents on there that talk about the impacts of surcharging, as well as the correct way to do it, and so on. So this is, if you like, a high-level oversight. We wanted to allow a lot of time for questions. But what I'm going to focus on today is really just outlining the principal rules that apply to surcharging and discount offers, and then give you some examples of when surcharging, or how not to do it, which is what we've seen a lot of in the market lately. And then just give a brief summary, and then allow a set of questions to come to be asked afterwards. At the same point, if people do have questions about the visa rules, one can email visa rules inquiries at visa.com. And there is a team behind that mailbox, visa rules inquiries at visa.com, who can answer any ongoing questions. So let's get into it. Now, I'm assuming I've got two screens and they're showing different things. So are we seeing the blue screen, the introduction screen, or are we seeing the screen with the slides right now?
We are still seeing the blue screen.
Still seeing the blue screen. Okay, so how do I get this one to change? Sorry, we don't use Zoom here, and is that still the blue screen?
Yes.
Oh, I love this.
Down at
Oh, here we go.
There you go. There you go.
Okay, I don't know what I did, but I'm going to try and do it again on the next slide. So let's talk about Visa's rules on surcharging and discount offer. Now, just to qualify, discount offer is what is the name of our rule. The idea behind the rule is to allow a merchant to offer an incentive of any type to use an alternative payment method. However, we know in the US, the primarily alternative preferred payment method is cash. So it's often referred to as a cash discount. I probably have already referred to it as that, and I'd probably switch between discount offer and cash offer. But technically, it's the discount offer rule. But again, the majority of times, in fact, not the majority, every time we see it implemented, the preferred alternative is cash. So just as background, Visa's rules have permitted surcharging and discount offers for over a decade now. They are encompassed within the Visa rules. They're part, as I mentioned, part of the public rules, but they are two very different offerings. What I've tried to do here at a more detailed level is lay out the primary differences. Now, one of the questions you may be thinking, if you can see the differences, why are some characters in these lists highlighted? And the reason that is because those are what Visa sees as the most common violations of these rules. So I'll drill into those a little bit deeper, but let me start. So let's talk about surcharging first of all. So the most foundational rule relating to surcharge is it is applicable to credit cards only. And that is not the public's perception of what is a credit card, which if you were to talk to my parents, for example, they will tell you, even though I work for Visa, they will tell you a credit card is anything that says Visa. Here at Visa, it is, and if you're in the payments industry, you will know that a credit card and a debit card and a prepaid card are not the same thing. So a credit card product is where the customer has a credit line, a line of lending, they borrow funds against that, they can repay in full each month, or they can repay a percentage and be charged interest. Debit card or a prepaid card, the funds are already there. And when you use that Visa product, the funds are immediately spent. So the surcharge, sorry, for someone. No. Gosh. Okay. The credit card are the only products that can be surcharged. Visa's interchange is generally a lot lower on debit cards, hence we do not allow surcharging. And prepaid is a form of debit cards. And to be clear, in the US, where one may select debit versus credit when presenting a debit card, which the merchant really means PIN versus signature or PIN versus no signature, that is still a debit card, irrespective of the selection made by the cardholder. So using a debit card and selecting credit is still using a debit card. It still means one cannot surcharge, because by selecting credit, all you're actually doing is saying you're going to input a signature or no signature versus inputting a PIN. So must only be applicable to credit cards. The second part, and as Nicole will recollect, this is a fairly contentious change that came into effect in April, which is the surcharge cannot exceed 3% or the cost of acceptance, whichever is lower. So if the merchant is paying a total merchant discount rate of, say, 2.8%, that is the maximum surcharge amount that they can apply. But if the merchant is paying more than 3%, a surcharge can still be no greater than 3%. And again, I've highlighted that here because that is the second most common violation we see on surcharging, is not only on debit cards, but also in excess of the 3% cap. Another important factor with surcharging is that the amount must be included in the total transaction amount, and it cannot be assessed as a separate fee. We get frequently asked, what is the difference between convenience fees, service fee, and surcharging? And the key aspect is that they are very different. Without going into too much detail, a service fee is the only fee that can be charged separately and can only be assessed by government and education merchants under Visa's rules. So a surcharge, just like a convenience fee, must be included in the total transaction amount. So if it's a $100 transaction with a $3 surcharge, the total transaction amount must be $103. It cannot be a $100 transaction plus a $3 transaction. They have to be combined. The fourth point relating to surcharge is the 30-day wait period after informing the acquirer of a merchant's intent to surcharge. So if you tell them on 1st of January, that merchant cannot start surcharging until 30 days later. The idea behind this window is twofold. It is one, ostensibly, if possible, to try and convince that merchant to not surcharge. Visa believes surcharging is it ignores the benefit of card acceptance over cash acceptance. Those benefits include higher average ticket value. If you have an EMV terminal and you follow the authorization procedures, you will have zero liability as a merchant. So if you're taking cash, there's a risk of counterfeit. There's a risk of being robbed. There's costs and effort associated with the handling of cash, the counting of it, the depositing of it. There's a risk of theft by an employee of cash. There are many benefits of card acceptance over cash acceptance that we think surcharging, or merchants who surcharge purely to recover their surcharge, oh sorry, their acceptance costs, we think those benefits are ignored. So we do have, and the information I alluded to on visa.com talks about what those benefits are. And Visa is in the process of developing a white paper, which we hope to release in Q1 24, further highlighting the benefits of card acceptance over cash. But the 30 days is for the acquirer to try and talk the merchant out of surcharging if possible, or at least bring them up to speed on the true benefits of card acceptance. But it is also to facilitate the technical implementation of surcharging. I mentioned about the surcharge amount must be included in the transaction amount, but in the 5th bullet, I talk about the fact that there is a field 28, which is part of the transaction record, and that the surcharge amount must be populated in that field as part of the Visa authorization and clearing records sent to us. That is generally something that can't be implemented overnight at a point of sale. And any surcharge that is assessed and cleared, if that surcharge field is not populated, it is again a violation. And I've highlighted it here because it is the 3rd most common violation that Visa sees of our surcharge rules. The surcharge is assessed, but field 28 is not populated. Additionally, Visa does require that the surcharge amount is separately identified on the Visa transaction receipt, and that there is signage at the point of sale and the point of entry for that merchant as for when the cardholder enters the building and goes to make their transaction. So they are clearly aware that there will be a surcharge assessed should they be paying with a card. The final piece that is very important here is that surcharging is not legal in all US states. As of today, the surcharging is still prohibited in Connecticut, Maine, Massachusetts, and Oklahoma. Those states still prohibit. We get asked, I probably get an email once a month now. It was a lot more popular before, as to whether or not surcharging is permitted in Oklahoma still. There was an opinion by apparently the outgoing Attorney General that it was not compliant. However, the law remains on the book, and a bill that was pushed through, that tried to push through the House in Oklahoma did not pass. So Visa's has a strong belief that despite what some entities may be pushing or stating, surcharging is still very much prohibited in Oklahoma. So those are our surcharge rules. So when one thinks about it, the basic principle of a surcharge is that a fee is added to a transaction for card acceptance. That is the outline principle of surcharging. Now, how does that compare to discount offers or cash discounting? They are very, very different animals. And what you'll see here in this list is a lot of the word no, a lot of appearances of the word no. The key fundamental difference of discount offers is that it must be a discount to the merchant's standard, stated, or list price. And I put that in bold because the most common implementation we have seen in the past is a merchant adding a fee and claiming that the goods were already discounted and that the price the consumer saw was the discounted price, and therefore by paying with a card, the merchant will add a fee back on. Now, if the goods, if the amount is already discounted and the customer picks up an item off the shelf and it says $97 on the item, and then they go to pay with a card and the price is now 100 because they're paying with a card and the merchant is removing the discount, that is not compliant with Visa's rules. The customer is not seeing the standard, stated, or list price. They are seeing the discount price. And Visa will treat that fee or that discount that is removed as a fee, and we will consider it a surcharge, which means then all the rules in the left-hand column apply. So if it's applied to a debit card, if it's over 3%, there's no field 28 reporting, they're in a state that doesn't allow it, we will consider that a violation. So it's very important that the price the customer sees is the price they pay. And I'll give you some signage examples after this, just to sort of help with that, make that message. In terms of products that it can be offered to, unlike surcharging, it can be applied to all card products. There's no debit restriction on discount offers. There is also no limit on the amount of the discount. It can be any percentage. Obviously, if you are just trying to offset your card cost of acceptance, you probably want to keep that discount at the same level as the cost of acceptance. But equally, Visa's rules do not dictate the scale of the discount. So it can be 10%, 20%, whatever you wish. But unlike surcharging, where it is absolutely capped to the cost of acceptance or 3%, whichever is lowest. There is also no signage requirements. Certainly, it is highly provident to place signage so that the customer knows that they can get a discount for paying with an alternative method. However, we do not require that, because from Visa's point of view, there's no need. If I pick up the item and it's $100 and I pay with a card and it's still $100, I didn't need to be warned about that. Visa's not going to dictate how you communicate your cash discount. There's no need for that. As long as the price the customer sees for a card is the price they pay with a card, then we're happy. There is no notification or wait periods, unlike the 30-day wait period for surcharging. There is also no transaction data requirements. There's no field that requires population of a discount amount in there. And sorry, just to focus, I sort of skipped over it. The wait period, if the merchant, if you want to implement discount offers today, there is no wait period. It can be done immediately. And then lastly, there are no state restrictions on our discount offer rule. So as you can see, surcharging is harder to implement and has a lot more controls around it and requirements around it. Discount offers are certainly a lot simpler. Visa is not an advocate of either, if I'm honest. However, we would prefer that if a consumer is paying with a card, that's the price they expected to pay from the get-go, and that they're not surprised with additional fees later. Visa is strongly committed to transparent consumer pricing. So those are the two fundamental differences between them. I do want to talk about implementation or some of the signage we've seen. I did put builds on these, and I don't know if the builds will translate on this. Yes, okay. So just to check, we did change the sign slide 4.
Yes, you're good.
Right, okay, thank you. My other screen is still on the old one, so I'm just going to go with this screen. So we have noticed, Visa has noticed over the last few years, as I mentioned earlier, a rise in discount offer, cash discount models. As you can see, the first two examples here use a cash discount descriptor. And it really started in about mid-2019. We started to see a rising number of complaints, essentially complaints about surcharging, both on debit cards and for excessive amounts. We noticed an increased deployment within the US market of and marketing of specific non-cash adjustment models, generally targeted at a small subset of merchant verticals. So we saw them in restaurants, both regular restaurants and fast food. We saw them in convenience stores, liquor stores, dry cleaners, generally small businesses. These are some examples of the signage that we've seen. So here's one saying, we're adding a 3.9% customer service charge to all store sales. But if you pay with cash, you get a discount. But then lastly, all the prices you see are cash prices. So it's hard to understand how this sign says there's a discount when in fact you're seeing the purchase price for cash, and that the discount gets removed by adding a service fee. That is a non-compliant model. Again, I'm picking up an item off the shelf. It says $97. I go to pay with card. They add on $3.90 or $3.86. For the next example, again, this one here says a customer service charge is applied to all store sales. And again, the same sort of thing. They will give, this was a bit of a twist on the model that we saw, which is basically saying we're going to apply a fee to all sales, but if you pay with cash, we're going to take off either that fee or most of that fee. Now, I will tell you, Visa's view is if you add a fee and then remove a fee, even if they're not the same, but the removal of the fee is based around your payment method being cash, we will consider that a surcharge. And again, the primary reason is that the cardholder is still not seeing the card prices when they purchase. They are seeing the card, they are seeing a price, and then when they pay with a card, the merchant is adding a fee. Well, as I mentioned, whenever one adds a fee, Visa will consider it a surcharge. So adding a fee and then removing a fee, even if they're not exactly the same amount, we will consider that a surcharge because the consumer is not seeing the standard stated or list price. So that one is also non-compliant. And then this one here, a 2.9% guest service charge. Actually, this is a very similar example. They add on 2.95%, but then if you pay with cash, they take off 2.5%. It's still a surcharge. It may not breach our 3% rule, but if it's applied to debit cards, if it's applied in Connecticut, Oklahoma, Maine, or Massachusetts, it's a surcharge. If field 28 is not populated, it's a surcharge. So that is also a non-compliant model. And to be clear and unequivocal, the only compliant that there is really only two compliant models. One is the customer sees the card price and a discount is offered off that, or the customer sees both prices. And I will talk about dual pricing in a minute. Just as a slight aside, we have also seen other interesting surcharge signage. This one was sent to me by a friend. It was a little bit awkward, to say the least. This one is also not compliant, as you may or may not guess. Not only the characterization of credit card companies, which obviously I'm not a fan of that characterization. Very importantly, though, it exceeds the surcharge cap of 3%. We won't, less we say about the rest of that notification, the better. So I did talk about dual pricing briefly, but I'll close up on that later. But what I do want to talk about and why this message has to go hand in hand with how surcharging should be done correctly is the fact that we did decide, as a result of the significant number of complaints that we were seeing, to develop a surcharge audit. So we developed that audit in late FY29, and our goal was to use mystery shoppers to go around stores using their debit cards and seeing if they got surcharge. And we were looking for 3 acceptance barriers. So surcharging is one, cash discounts or discount offers are another, and then minimum card spend limits. Just as an FYI on that last piece, a merchant in the US may set a minimum transaction amount of $10, cannot exceed $10. But again, like surcharging, it can only apply to credit cards. So if you go to a merchant and they say minimum purchase on card $5, and they don't limit it only to credit cards, that too is a violation. So our surcharge audit, we call it the unwelcome acceptance audit, which is designed to identify anything that would dissuade customer from using their card. These were the 3 items we were looking for. We planned to start that audit in early 2020. As one could imagine, that didn't happen due to the pandemic. So we did start it later in Q4 FY21. And we've taken 3 separate audit approaches. One is in-field audits facilitated by Ipsos, a mystery shopping company. They use in-field auditors to go into stores, take photos, record their transactions and signage and so on. We also went to the acquirers and asked them to make attestations on behalf of ISOs that were offering cash discount, surcharge solutions to ensure they comply with our rules. And we've also had a limited scale staff ambassador program where we have encouraged a small set of sales employees or employees in our sales group to report anything they see to us. And I would say, my team have been active in that space, and indeed my wife is active in that space. She tells me about every time she gets surcharged, and we launch cases. But we've been doing that audit now for a couple of years, and these are the results that we've seen so far. I've just updated these. So as of 1st of November, Visa's audited 49,000 merchants, and that doesn't mean there's 49,000 individual merchants. That actually means some of those are re-audits. And the way it works is if we audit you and you pass, and by you I mean a merchant, and you pass, then we're good. There's no action to follow up. However, if the merchant fails the audit, we raise a compliance case. We ask the acquirer to address it within 30 days, and generally that happens. But we also advise that at some point in the next 6 months, our auditor is going to go back to the store and verify if the merchant is correctly following our rules now. In the initial, the overall findings, those 49,000 merchants, is we had failure rates of 34%. Now, the first round failure rates were often in excess of 50%. But then we saw re-audit rates still over 30% in many instances. It depended on the ISO. Some ISOs saw the audit, got notified of the audit, remedied their models to comply with our rules. Other ISOs amended their models to make it harder for the auditor to find the violation. And we have had some unfortunate instances where auditors have been thrown out of stores. We've had them threatened. And we have engaged with any ISOs and sponsoring acquiring banks where we have seen that happening, being quite unequivocal about what we expect and not expect to happen as a result of these audits. And we retain the ability under a construct of our rules to terminate any ISO who would be a registered third-party agent with Visa, to terminate their ability to participate in the Visa payment system. I will tell you, we have not done it yet, but we have come close in a couple of instances. And I will say that any consistent, repeating violations, that option remains on the table if we need to. But we're not in the business of taking businesses out of business. We want everyone to be successful in the payments system. We just want people and expect people, if you're going to participate in the payment network, that you follow and adhere to the network rules. So we've had a lot of audit activity. It's been picked up in the media quite a lot. Our audit has made quite a few headlines. In November, I went to several conferences to talk about the audit and to try and get our message across. And in terms of beyond the media, the impacts that we're seeing on this is we are seeing a broad change. It's slow, but it is happening. We are seeing acquirer surcharge models pivot to compliant models, and a compliant acquirer surcharge model would mean that one cannot expect the person taking the payment at the fast food restaurant or the liquor store to be able to identify whether or not it's a Visa debit product or a Visa credit product. That's just too much to ask. Moreover, I'm sure, like many of you, I make the vast majority of my payments using my smartwatch. So there's no card for the merchant to see. So a compliant surcharge model would facilitate bin tables, and Visa releases a new bin table every few days, and it will have products in there. So it will tell you whether or not, based on the bin, if it's a debit product, a credit product, a prepaid product. So leveraging those bin tables in a valid surcharge solution is absolutely essential. And I would tell you, it is something we're thinking of implementing as a rule at this point. As well as that, obviously populating field 28, that's a technical enhancement. And then, other things like I worked with a large terminal vendor in the UK to ensure that their surcharge solution had a physical 3% cap built in, so that a merchant, when they're setting up surcharging, can't elect surcharge 4%. It also contains state blockers, so that a merchant located in Connecticut could not switch on that functionality, for example. And again, I think the more technically sound the solution is, the less likely you have the risks of there being a violation. And I think it's absolutely essential when deploying these solutions that one does not create a surcharge trap for a merchant. Let's let the merchants be experts at making pizzas or selling donuts, whatever they need to do, and let the payment professionals provide them with a solution that not only complies with Visa rules, but prevents the merchant inadvertently breaching network rules and receiving a compliance case as a result. We have seen significant shifts in the discount model discount offer solution to dual pricing. So like one would see at a petrol station, that is totally compliant. You can do dual pricing. However, the absolute caveat is, and at the Western States Acquiring Association in November, I spoke to a number of vendors who are deploying dual pricing, and the point of sale shows both prices, which is great, card and cash. However, if the customer is still picking an item off the shelf and the item is based on the cash price, and then what they see at the POS is a card price and a cash price, then that is still a violation. The the cardholder must see the correct pricing all the way through. The dual pricing only works if you update the shelf pricing or the per item pricing. Think about how it works. The most common model of this is petrol stations. In petrol stations, you see both prices. Wherever you look, you see both prices. And if they're only going to display one price, it must be the card price. But what we've seen is a number of models where they say, well, we heavily encourage the merchant to update their prices. That is a compliance trap, because I guarantee half those merchants will not update their pricing. So if one is going to deploy a dual pricing model, it must include the requirement that all the prices shown are either both prices or at a minimum the card price. If not, it will get treated as a surcharge. And again, last point here, a lot of discussions in the industry. The reason I went to WSAA, the reason I went to ETA the week after, was because I was asked to come along and talk about our surcharge audit, our surcharge rules, and cash discounting, because it's such a popular subject right now. Now, as for in summary, as for the final steps, Visa remains committed to continuing the audit through FY24. It's just been funded. We are planning to continue. We are going to expand the geographic areas where we're auditing. We are also going to expand the number of ISOs that we're doing not in-house, but attestation-based audits with. But as I mentioned to you earlier, one other thing is we are still considering rule changes to ensure improved compliance with our rules. And like I say, an example of that may be that we state in our rules, if you're going to deploy a surcharge model, it must facilitate bin tables, or it must utilize bin tables to ensure debit cards are not surcharged. Aside from that, I would summarize, in summary, say, look, Visa remains committed to allowing surcharge and discount offers. I don't think I've been shy in saying it's not something that we as a network are a fan of, and we think, to reiterate, it overlooks many of the benefits of acceptance, but we have no plans to take either of these options away. But what we are dedicated to is ensuring that when surcharging or discount offers are made, that they are done in a compliant manner. And we remain dedicated to ensuring transparent consumer pricing in accordance with network rules, so that when our cardholders make purchases on Visa cards, they are seeing a fair representation of pricing as Visa permits it today. That is our goal. That's our North Star, if you like, and we remain committed to that, and we will continue to push towards that goal in FY24.
Thank you, Robert. Right now, we're going to transition into the Q&A section of the webinar. As all of you are aware, when you were RSVPing, you had an opportunity to submit some questions. So we're going to use this time to ask Robert some of these questions and walk through those together. Again, as a note, Robert is not an attorney, so we did go through these questions and remove any that kind of ventured into that space of providing legal advice or any sort of legal opinion. And we're going to try to get through as many as we can during our time together. And so if you feel as though a question that you submitted was not answered during this webinar and would still like to have your question answered, please feel free to reach out to your respective firm, and we'll be happy to assist. But we're going to jump in now. And Robert, I know you just spent a ton of time going over the discount offering and surcharging and kind of what the difference is. But I think this is such an important topic that if you don't mind, can we kind of walk through one more time, at least in regard to like display and notices, what really is Visa looking for as far as the discount offering and the surcharging? What needs to be customer facing here?
Great. Yes. Yeah. Great question. So we actually have examples on visa.com of what we expect the signage to be for surcharging. And essentially it is, there's really 2 or 3 main requirements. One, the percentage must clearly be explained and reference to credit cards. The fact that there needs to be a statement that it does not exceed the merchant's cost of acceptance. We don't expect the surcharge to be a revenue generating opportunity, which is why we reduced our surcharge cap from 4% to 3%, because we saw a ton of surcharges at 4%. And we knew that wasn't the MDR that the merchant was paying, or equally the MDR was a lot higher because the merchant essentially didn't care about how high merchant discount rate was, because they were passing it on to the consumer. So we clear statement about the percentage, clear statement that it does not exceed the cost of acceptance or the merchant's MDR. And then the other one is a bit more, it's a bit looser. We don't describe exactly what they have to say, but it cannot be represented as a fee assessed by Visa. That is a primary thing. And again, I know that a lot of merchants, consumers don't necessarily know what Visa is. I will tell you, I've been with Visa 18 years in the US, 4 years in Europe. My parents still don't know what I do for a living. When the merchant says, well, that's Visa, a lot of the MDR they're paying is not a Visa fee. It's fees to the ISO, it's fees to the acquirer. It's not a fee that Visa's assessed. So it cannot be represented as a fee charged by Visa. And I can tell you, we have had complaints in lately where customers, cardholders have been angry at Visa because they got surcharged. And they were angry at us because they were told Visa was charging that fee. And obviously we were not.
So in relation to restaurants, and you touched on this a little bit, but with a fast food restaurant versus one that you walk in and maybe you're handed a physical menu, if you are going to implement dual pricing, kind of what are some best practices and what can we look to do to be compliant in those scenarios?
Yeah, I mean, great question. So the absolute simplest way is have the card price per item. And then have a statement about that these prices will be discounted X percentage if you pay with cash. The alternative is have both prices, both card and cash, alongside each other. It is one of those things, personally, I find it incredibly frustrating if I go to a restaurant and they add on a fee after, and this is often isn't even a Visa fee. They're adding on a COVID recovery fee that has nothing to do with how you're paying. It's 4% across the board. And when I look at it, when I go to a restaurant and they're producing paper menus once a week or even once a day, there really is no reason not to increase those prices, to incorporate that fee, or if you're adding a fee for card acceptance, to incorporate it into the prices. There really is no reason. So, but if one isn't going to incorporate the cost, then you either need to see only the card prices or the card and cash prices simultaneously next to each other per item. Anything else, any fee added on at the end just for card acceptance is a surcharge, period.
And again, when it comes to signage, if we are going to be implementing or they're looking to implement a surcharge, where does the signage need to be?
So great question. So point of entry. So at the entrance to the restaurant, there needs to be signage saying so there will be surcharges applied inside the premises for use of card. We ask by the point of sale. Now in a restaurant, that's often you're not at the point of sale. They're bringing the check to you to pay. So in those instances, whilst there should still be a sign by the point of sale, cognizant that most cardholders don't go to the point of sale, then we would expect something either clearly disclosed on the menu or clearly disclosed on the check when it arrives to say, if you pay with card, you'll pay this much. We recognize that a restaurant where one sits down and they bring the bill to you at the end is not quite the same environment and purchase environment as, say, a liquor store or fast food. Sorry, not fast food. Well, yeah, it would be fast food or a convenience store.
Yeah, so a little bit more flexibility there as far as
Yes.
what that point of sale means and looks like.
Yeah. And to your question earlier, which I realized I didn't quite fully encompass, in terms of discount offers, we don't have any signage requirements for those. So it's only signage requirements for surcharging. But if you're deploying it correctly, then the customer sees the card price anyway. There isn't a surprise when they go to the card, which is why we don't dictate signage for discount offers.
Right, just try to make it as transparent as possible throughout.
Yeah, I mean, that's definitely from a personal consumer point of view. I like to know my options. And so, yeah, you don't want your cardholders or your customers will be happier if they're not surprised with the payment options.
Absolutely. Ashley, I'm going to turn it over to you now.
Thank you. So Robert, you've already discussed that a debit card, regardless of how it's run, cannot be surcharged. But I do think that there are some questions that relate to when a customer bypasses entering a PIN in and submits the transaction to Visa via the signature debit, and it rides through the Visa's credit rail. How does a merchant prevent surcharging in such scenarios, given that they rarely take physical possession of the card and to note it and differentiate it from debit versus credit?
That's a great question. Nice to see you again, Ashley.
You too.
So yes, so it's, you know, the selection of PIN versus not PIN is obviously a very unique American situation. It confused me a lot when I moved here from London with my debit card, and I kept being asked for a PIN, and it didn't work because it was an online chip, offline chip PIN. But to me, for surcharging, that's where terminal logic comes in. And again, I think it's you cannot rely on, you really can't rely on the cardholder telling you what product they have. And you certainly can't rely on the merchant identifying which product they have. A lot of our debit cards don't even say debit anymore. Or if they do, it's hidden on the back somewhere. So terminal logic is the only way, if you're going to surcharge, to make sure that you're not surcharging the wrong product. Now, to be clear, if one selects, when they say debit or credit, and debit really means PIN, and that means it gets routed to a PIN debit network. The only ones Visa has an interest in, we have PAVD, PIN Authenticated Visa Debit, where it comes through the Visa network, or we have Interlink, which is Visa's PIN debit network brand. But there are many other networks like Star, Nice, Pulse, where that transaction may get routed. And once it routes off to a different network, Visa's rules no longer apply, and those network rules would apply. I can't speak for whether or not they allow them, but most debit transactions are priced extremely low. And often the reason the merchant is routing to an alternative debit network is for pricing reasons. So the need to surcharge is probably a lot lower as well. But certainly, if it goes over Visa or Interlink, irrespective of CVM, cardholder verification method, PIN or signature, no surcharging is permitted because it's a debit product.
I appreciate that. So I also wanted to talk about something that you and I have met with and discussed. You've touched on how robust the efforts are for Visa to identify surcharging on debit cards. Can you discuss a little bit about how complaints are registered and how that relates to penalties in the process that Visa goes once they've either identified someone not being compliant or received a complaint from a customer?
Yeah, great. Yeah, so we get our complaints generally come in from two primary sources. The first one is we have proactive compliance. That's where we go out and we look for the compliance. Our surcharge audit is a classic example of that. The other types of complaints we get are reactive complaints, and they generally come from members of the public or they come from issuing banks. We occasionally get ISOs complaining about other ISOs or acquirers complaining about other acquirers. Excuse me. But the majority of those complaints, I would say the vast majority come from consumers. And they do one of two things. They either write to their bank and their bank forward the complaint to us, or they go directly to visa.com and complain on visa.com. And there's a consumer complaint form on visa.com. And in the last year, we received about 6,000 complaints, the majority of which are around surcharging. And what happens is it goes through, I have a large compliance team. It goes through, the case gets assigned to the team. They look at the evidence that's been presented. If they see it as a valid complaint, because sometimes we get surcharges, someone saying, I got surcharged 2% on my credit card in California, and it was on the receipt, it's in field 28, there was signage. And in that instance, it's not a valid complaint. But the majority are valid complaints because they're debit cards or they're excessive. So we look at the complaint. If it's valid, we identify the merchant in VisaNet. We then identify who the acquirer bank is, and we raise a compliance case. And that means we send an electronic notification to the merchant's acquiring bank. We detail the complaint and which rules have been violated, and we give them 30 days to remediate the situation. The options are, the acquirer comes back and says it's been fixed. They come back and say, no, the merchant's not surcharging, and they give us an explanation, which may be valid as to what the fee was about. And sometimes that does happen. Or the the acquirer doesn't respond at all. In that latter instance, if the clock runs out on that case, then the surcharge, a non-compliance assessment for a core rule violation is assessed. And that fine is $25,000 for the first instance. Now, for our surcharge audit, because we've found so many violations, we've only been assessing $5,000, which is a product and service fine. There is also, if it is a valid case, there is a $1,000 compliance case fee that is assessed when the case is opened. And there's no avoiding that fee if it's valid. If it turns out not to be a valid case and we get more evidence, we'll refund that fee. But if it is a valid complaint, then there's an immediate $1,000 fine against the acquirer. And to be clear, we only fine the acquirer. We don't fine the merchant direct. And it's for the acquirer to decide, did the merchant breach a rule I told them not to breach? Is the ISO facilitating a invalid model? They decide what to do with the non-compliance assessment, but we assess it directly to the acquirer. So $1,000 fee when the complaint is opened, potentially $5,000 or $25,000 fee if the complaint goes unanswered, but most of them get answered. And if the acquirer needs more time to investigate and it's a reasonable extension, like if someone came to us today and said, can I have until January 15th because of the holidays, we would give them that extra time. But yeah, that's how the fees work. But one important difference is if we are told the situation is remediated and we get a repeat complaint that is valid within 12 months, and that could be a consumer complaint, it could be a re-audit of that merchant, then there is no waiting period for the assessment of that next fine. So if we're told in January the merchant's not surcharging and it's been fixed, and then we get a new complaint against the same merchant in April, and they're doing the same thing we were told they stopped, there's an immediate $5,000 or $25,000 fine that gets applied to the acquirer in that instance. As you can imagine, we take this very seriously, and the fines are meant to represent the amount of gravity we apply to these violations.
So, and I just want to make one little clarification here. I know the $1,000 fee is non-refundable if there is a valid complaint. What about the other fees that are issued by Visa? If there is a fee that's issued by Visa to the acquirer and the matter is corrected and stays corrected, are those fees something that is taken off, or are they supposed to pay that fee based on the assessment?
If the acquirer responds to the case in a timely manner, then apart from the $1,000 case fee, we never assess the other fees. We'll only assess it if the acquirer fails to respond to the case by the deadline, or if it's a repeat violation of something we were told was previously fixed. So I can tell you the vast majority, easily 95% of our cases, beyond the $1,000 case fee, well over 95% of our cases have no fees associated with them. They get resolved and the case is put to bed.
Perfect. Thank you. I'm going to pass it back over to Nicole.
Thank you.
I'm going to piggyback off kind of what you were just discussing with Ashley. As far as these fines, I know they're a big concern for a lot of our clients and how they're passed down. And you've mentioned the $1,000 fine, the $5,000 fine, and kind of what the differences are there. Is there anywhere on Visa's website or anywhere that they can go and really see this outline to kind of know what different violations and what fines are associated with such violations?
Yes, absolutely. If you went to the visa.com and downloaded the rules, and then you looked up the phrase, it's a PDF document, you can search on it, non-compliance assessment. I don't have the rule up in front of me, but the table of non-compliance assessments is detailed in the rules. As well as the rules, there's a construct which describes what's a core rule and what's a product and service rule. And essentially everything that's in chapter 1 of the book is a core rule. So in chapter 1, for example, it says no surcharging at all, but there's an exception in the US for credit cards. So if you surcharge a debit card anywhere else, or surcharge any credit card, or sorry, any card outside the US, there's a few country exceptions. But let's say in Mexico, you surcharge a Visa card, that core rule says no surcharging on Visa cards. So that's a core rule violation. If you surcharge a debit card in the US, because that rule says you can surcharge credit but not debit, then you're violating that core rule. So that's a tier 1 NCA, which is starts at 25,000. The rest of our surcharge rules, things like disclosures, field 28, those are product and service rules. They appear in chapter 2 onwards. And anything in chapter 2 onwards is a tier 2 non-compliance assessment, which is also a table. And those start at 5,000. So in the rule book, if you just download it, looked up non-compliance assessments, probably on about the 4th hit, it will take you to the compliance process and an explanation of those tables and an explanation of their usage.
Perfect. We also had a few questions come in, obviously with some of these rules and everyone learning kind of like how to be compliant and how they're wanting to implement them. If a secret shopper were to come in and let's say the way they're processing the cards and everything about their program is compliant, but they've left up an old sticker or there's an old sign in the window that they've totally forgot about, are they still going to be assessed at that point, or how does Visa view that?
That's a good question. I don't think we've necessarily seen that yet, but if for example, the auditor finds a sign in the window that says you'll be surcharged 4%, and they go inside, they use their credit card, let's say. The auditors aren't using credit cards, by the way. They're only using debit cards because it wouldn't prove as much as we want to prove. But let's say they use their credit card. Well, actually, let's say it's a card holder, just a regular card holder. Sign says 4%. They go inside and they get surcharged 3%. Everything else complies. We might raise a compliance case and say your merchant has the wrong signage, but we wouldn't consider that to be a violation. It would be considered clearly a much bigger violation if there were no signage, or the signage said 3% and the merchant surcharged 4%.
Absolutely.
So there are definitely degrees of violations. We see some as definitely more serious than others. Like surcharge on debit, surcharge over 3% is massive. Not populating field 28 is very significant.
Right.
Not having strictly the best signage is a violation, but it's definitely down the rungs of the ladder in terms of importance to us. Really, what we're focused on is clearly the pricing aspect and the consumer experience. And signage at the entrance, I would argue, most cardholders don't even notice it anyway. And the auditors look for it because we've told them to look for it, but most cardholders don't know that. And I can honestly say when I've been surcharged, I've not even looked at the point of entry to see if there was signage there, because what I'm more focusing on is the product that was surcharged and how much, and then population of transaction data.
That makes sense. Thank you. I'm going to turn it back over to Ashley. I know we had several scenarios come in. That was just one. So I think she's going to go over a few more and get your opinion on those.
Sure.
Thank you, Nicole. So I know we touched base on this, but I really want to make sure that everybody understands when it comes to discount pricing, the discount percentage is not, it can be whatever they want to be. It's not bound by the surcharge percentage or any other percentage that's been issued by Visa, correct?
Correct. Yes, absolutely.
And then in regards to that discount program, while we typically call it to be a cash discount program, that can really be for any form that they want it to be, whether it's ACH or check. It's whatever they deem to be that discount.
Magic beans, yeah, whatever payment method, firstborn child, whatever the merchant wants to take as an alternative payment method. If they want to incentivize that by offering some sort of discount, they may. Yeah, absolutely.
And then you talked about the situation with restaurants, but I wanted to go into situations where we have a card not present environment, and what is a compliant way to provide notice about a surcharge or a discount program where they have an environment of card not present?
Yeah, great question. So it's normally we're a little bit less prescriptive about this, I think I'd say, and the reason being is most merchants in the online space don't surcharge. And there's really, in Visa's opinion, and my opinion, there's really two reasons for that. One, it is a lot easier to update your pricing when doing an online. You've got an online store. So it's not like going around a convenience store and physically changing all the labels. You can do it electronically. It's easier. Two, there's really not many alternative payment methods many merchants accept online. We have seen ACH, but even that is less common. Generally, many online merchants accept only cards. So they build the cost of acceptance into their pricing because there's no alternative payment method. Certainly, if you're doing an online transaction, you're not paying cash. So the merchant aren't making the equivalence between the cost of accepting cash versus the cost of accepting card. And in fact, probably an online merchant should probably charge more for handling cash, taking cash, than they should do a card. And then, so that's the second one. There's just cash is not really a competitor in those environments. The third one is that merchants, cardholders tend to vote more easily with their feet with online pricing. So if I'm on a website and last night I was buying some parts for one of my cars, and I realized that there's about 3 companies that sell parts for these cars. Now, none of them surcharge, but I guarantee if one of them did, I would not use their business. And it's a lot easier to abandon a cart for a consumer if they get surcharged and go to a different website than it is having sat in a restaurant and eaten a meal and then decide you don't want to eat that meal anymore when you realize you're being surcharged, or picking up items, physically picking up items around the store. That there's, it's harder to abandon that cart. Online, it's a lot easier. And we think for those 3 reasons, that's why we see a lot less surcharging online. Nonetheless, if a merchant may surcharge online, that is absolutely fine. The same rules apply. In terms of disclosure, it really should be sort of on the main web page. If you think of it like the point of entry to the website, there should be some sort of disclaimer saying we will surcharge X percentage for cards. And then again at checkout, as part of the checkout process, we would expect the surcharge to be sort of highlighted there. And again, the other requirements apply. If that merchant is based in Connecticut, Maine, Oklahoma, or Massachusetts, they can't do it. They will need to still populate field 28, and it will still need to be a separate line item on the cardholder's transaction receipt. So the mechanics of it are identical. The only piece is signage is in different places. And again, for the three reasons outlined, we see surcharging as far less common in the online space.
There's a lot more pitfalls and traps when you try to do it online where card not present.
Yeah. And again, it's been available for over a decade, and we have not seen a growth in surcharging online because for the reasons I outlined.
Absolutely. So to have a compliant receipt, must a merchant show both itemized prices as far as both the cash or the charge part, or can it simply just show the tender type?
The receipt can show Visa's rules do require a description of the goods or services purchased on the transaction receipt. Now, we don't necessarily describe as to what detail. So that is less of a concern for us in terms of that disclosure. But nonetheless, for us, it really goes back to the pricing that the customer sees when they were selecting items. So, our auditors, for example, they get transaction receipts and it just says, card price, and that's fine, but they are trained to take photos of the menu or the items on the shelf to make sure that whatever they picked up, if it said $10, it's still $10 on the transaction receipt. That's not now $10.30 and that being displayed as the card price. So we do expect this sort of consistent through line of pricing, even if it's not ultimately detailed on the transaction receipt. But I think it's fair to say the more detailed the transaction receipt, probably the happier the consumer and the less likely one is to get a compliance approach from Visa.
Absolutely. You mentioned convenience fees, and I wanted to spend a little bit more time on this because in addition to convenience fees, I believe Visa has also found that there are merchants that are being creative in the fees that they are trying to assess. So can you kind of let us know from Visa's perspective, the issues or pitfalls that we find when we talk about adding certain fees on at the end?
Yeah, this is a great question. I'm glad you asked this. So, and I would tell you, I regularly do sessions with our lawyers at Visa to explain the difference between a surcharge, a convenience fee, and a service fee, because they're not the same. There are fundamental differences. So let me start with the principle that as a merchant, no matter what you call this fee, if you are adding a fee for card acceptance, it is a surcharge. I showed those examples of signage earlier. They can call it a customer service fee, call it a convenience fee, call it a payment fee, non-cash adjustment, whatever. If you're adding it on top of the price the customer saw to make a purchase, it's a surcharge. Now, convenience fees themselves, I mentioned service fees, which are government and education only. The other fee that Visa allowed is a convenience fee. Now, we have, again, it's in the Visa rules. If you download those Visa rules and search on the word convenience fee, it would take you to that section in Chapter 5 that talks about convenience fees. Convenience fees are a very unique being. I tell you the fundamental pitfalls with convenience fees. They cannot be assessed by a merchant who only operates in the card absent space. The idea of the convenience fee was to pay for the channel. So a good implementation of a convenience fee is you want to pay your, here you go, good example. You want to book tickets using your air miles to London. You can do it online and just pay for the tickets redeem your air miles, pay for the tickets. But if you want to call the call center and have someone talk you through it, they may charge a convenience fee of $10 because that's not convenient for them. It might be more convenient for you, but it's not convenient for them. So the idea is it's there to pay for the channel. And a good example of that is if you think about you want to buy tickets to go and see, I don't know, England lose another game of cricket against the West Indies, which I happened to do last February. I could buy my tickets for the stadium online and pay a convenience fee. Equally, if I wanted to avoid the fee, I could have flown to Antigua 6 months early, gone to the stadium, bought my ticket from the box office and saved the $7. But I would have just flown to Antigua to do it, which wouldn't have been a bad idea now I think about it. But anyway, I am paying a fee for the convenience of the online channel. Now, do we think they still get used to pay for the channel? Absolutely not. I don't think they do. They get assessed because they can be assessed. But if we find a merchant who's charging a convenience fee, but there's no fee-free channel for the customer to pay with, and it's an online-only merchant, they are not permitted to charge a convenience fee. That fee should be built into their pricing. The other key violation we see with a convenience fee and a requirement for convenience fees, it has to be the same fee charged to every payment method in that channel. So the other common violation we see is you go to a website and they say, if you're paying with card, it's a 3% convenience fee. If you're paying with cash, or sorry, not cash, ACH or e-check, it's a 1% convenience fee, or there's no convenience fee. At that point, because it's not being applied to every payment method, and only being applied to cards, it's no longer a convenience fee. Guess what? It's a surcharge. The other key piece for convenience fees is it cannot be an ad valorem amount. It cannot be a percentage. It has to be a fixed fee. So it's got to be $3.95, $10, whatever it may be. We don't dictate the size of the fee, but it must be a fixed fee. It must be applicable to all payment channels. Sorry, all payments accepted in that channel. And it can't be assessed by an online-only merchant.
Perfect. And then we had a question come in that we feel like is probably a pretty common question for a scenario that we just wanted to provide to you so we could be very clear on this stance. So can a merchant put a sign that said, do not accept debit cards? And if they want to use, if the customer comes in and wants to use the debit card without a PIN, a surcharge of 2.99% is going to be applied?
Oh, absolutely. Yeah. So the answer is absolutely not. Well, there's a yes and a no. Let me just clarify. A merchant can become a limited acceptance merchant, which means they can elect to only accept debit cards or only accept credit cards. They can register with Visa. The email is limitedacceptance@visa.com. They'll give you all the information. But what that means is that merchant has said, I'm only going to take credit products or I'm only going to take debit products. Now, a good example of that today is merchants who do debt repayment. Visa does not allow debt to be put on credit cards. There's no legal reason for that. We just think it's a good stance to not allow debt to be put onto debt. So merchants who accept debt repayment can only accept debit cards. So they are by default a limited acceptance merchant. So you can accept either debit or only credit. However, as I was saying earlier, having the customers on a debit card select debit or credit, they're still using a debit card. All you're actually choosing is this cardholder verification method, the CVM, whether it's PIN, signature, or no CVM. That's all you're selecting. But fundamentally, they're still using a debit card. So if you assess a surcharge, you're still accepting a debit card, you're still surcharging a debit card, you're still violating Visa's rules. But you could decide to be credit card acceptor only. Limitedacceptance@visa.com is the email address for that.
Perfect. Thank you. I'm going to pass this over back. Oh,
yeah. Yes. And if you looked in the rules under the term limited acceptance, you search on that term, it will take you to the limited acceptance rules.
Thank you. And I'm going to pass this back to Nicole now for a couple more questions before we run out of time.
So we've heard a lot about Visa's website and being able to navigate it. And I know you and I have talked about it, and Visa's website is kind of admittedly not the easiest to navigate. You have to have like the right search words. So I heard you mention that there are examples of signage and different things online on Visa's website. And I might be putting you on the spot here. Do you know exactly how we can find those, where we can point people to? And if not, right off the top of your head, we may collect that from you so that we can pass that on.
Yeah, I think it's a great. I know we talked about this at ETA. We are trying to. I actually have one of my team looking into how to make it easier to find. It used to be the word surcharging surcharging
Mhm.
would take you there. And I'm not sure that's strictly the case. And where our surcharging information is based, it's on a page that has 3 separate tabs further down the page, and it's the middle tab.
Okay.
But normally surcharging is, if you listed surcharge or surcharging, it will take you to some of the documents, but it won't necessarily take you to the page where all those documents are linked. So I can
you've
follow up.
mentioned so many like
Yeah,
useful documents, and I'm trying to make sure we can map where exactly that is, or
Yeah.
keywords that we need to be giving in order for ourselves to find, but also to hand off to our clients, and then they can help merchants as well.
I can follow up with an email with the exact link. I'll send you the exact link, and then if you share that link, and there's a kind of one instruction, which is go to the middle tab on that page,
Okay.
and then the rest of the information is there.
Perfect. Yeah, that will be very helpful. We also had a question come in. Is there any way for processors to see if a merchant has prior visa violations?
That's a great question. It's a lot of good questions today. We get asked that a lot. There isn't today. We have advocated for quite a while now. This is an industry level thing. Obviously, we have listed merchants that we terminated merchant file. That terminated merchant file does not include termination for non-significant rule violations. And what we mean by that is they're not selling child pornography or stuff like that. You know, that's where merchants or large-scale fraud, those are the ones that get on the terminated merchant file. There isn't a way to go on there and check for just regular rules violations, and our view is that there probably should be a bit like credit histories for consumers, but there isn't today, unfortunately. It is unfortunate because sometimes we see the response to a compliance case is that the acquirer simply terminates the merchant, which, I mean, problem solved for that acquirer, but I would imagine that merchant still needs acceptance. And as a result, it's just going to go on to the next bank, get acquired, and then potentially do the same thing, particularly if they're not properly explained to why they were surcharged. And that's been one of our pieces when we talk to our acquirers, is saying, look, if you are going to terminate merchants who are surcharging, and it doesn't happen often for the first time, but generally when there's a repeat violation and the merchant and the acquirer knows they've tried to educate the merchant and the merchant's done it anyway, that's often when they get terminated. And we try and we ask the acquirers to tell the merchant, look, this history travels with you. So if I'll just choose some examples, we have a merchant who got caught terminating under Chase, maybe twice. So Chase terminate them, and then they get acquired by Fiserv. And Fiserv bring them on board. Well, if we catch them surcharging again, it's technically their third violation. Now for Fiserv, they're saying, wait, we've only had them a month. You haven't written to us before, and we will share under their previous acquirer, we won't name them, but their previous acquirer, we caught them surcharging on this date and this date. So really the best thing, without such a database in place, and again, we do advocate for it, the best thing is to do two things. If you're offboarding a merchant, is make sure they understand that their history, any violation history of Visa, stays with them. And secondly, I would say, legitimate, serious questions of your merchant when you're onboarding them. Why did you leave your previous acquirer? If they say, well, I was terminated, you probably want to ask a follow-up question and say, well, why? Because if it's surcharging, then that's your window, your opportunity to educate them. If it's fraud or something like that, you probably don't want to continue with that onboarding. But right now, without that tool in place, ask the questions, be inquisitive. There's nothing to stop a merchant lying to you. But if they do, and we catch them again and we're able to prove it, then as an acquirer, you have every right to say, look, we asked you if you've been terminated for rules violations before. You told us no. Visa's just told us you had compliance approaches on these dates, and we will share the dates and what the violations were. Perfect. Thank you.
One last question on my end. Just when rules do trickle down and you know you have an update like the 3% cap, what's the best way to keep up with these rules? Just make sure that people are staying on top of it. Is there anything that they can sign up for to get these notifications? Any place they should be looking? How do you guys broadcast those?
Yeah, so every rule change, we issue something we call a Visa VBN, Visa Business News article, or Visa Business News, and it's a brief document that says Visa is updating or introducing new rules regarding X, and we'll give a summary of the changes. Be fairly high level. We don't want to make them so long that people can't read them. We also select the audience. So if it relates to a merchant, for example, we will make the audience, acquirers, processors, third-party agents, and merchants. So it will have a described audience in the just below the title as to who it should be circulated to. Now, most of those documents are still Visa confidential, so they're for client use. But what we would expect is, say, Wells Fargo to receive that notification, say, right, I'm going to give that to my merchant division. They are then going to distill it and share it with their merchant database. So that's how we broadcast every change. It always happens within 2 weeks of the rule change approval, whenever that was, and we change rules throughout the year. But the other piece that one should remember is most rules, we make them effective with the business enhancements release, which is mid-April or mid-October. And that's also when we publish our new rule books. Every 6 months, we publish a new rule book. So if we make a rule change in May, it's very unlikely it's going to be effective until October. Occasionally, we might have to make it effective in a very short time frame. Maybe it's a risk that we're trying to close down. But the majority of the time, we choose one of those windows. And so it appears in that next rule book. And what I always advocate to people, if someone's interested in the rules, which is kind of just worrying, but nonetheless, we're all geeks, I think, to some extent, it's only my group. Then what I always say to people is when that new rule book comes out is go to the summary of changes. The second section of the book is the summary of changes. And it will give you a couple of lines about a rule change that has occurred. It will give you a hypertext link to every rule that's changed. So you just click on it and it'll zoom you straight to that part of the PDF where that new rule is. And it will also have a hypertext link to that VBN. Now, the caveat to the VBN is you need to have access to Visa Online. So ideally, you would be a member of Visa to be able to do that. But the VBN is tied to that summary of changes. But you don't need to see the VBN if you're looking at the summary of changes, because it will describe the change and then you can click and it take you straight through to the change. And every rule book, there's about 60 subjects. Some of them are 1 rule, some of them are 20 rules, but they're ordered by global rule changes, North American rule changes, Latin America. So you can instantly pare that list down to maybe 20 rule changes if you're in North America, for example. So I always advocate every time that new book comes out, download it from visa.com, go to the summary of changes, and just read through and see what's changed. And if you're in with an acquirer and they can also share that information with you when we publish the VBNs, which can be 5 months ahead of the book, then even better. But the information is there. We don't try and hide the changes. We make them very public. We want people, the reason we change the rules, there's obviously a driver for changing the rules, and we want people to adhere to those rule changes. So we're not in the business of trying to obscure them in any way. We want them visible.
Absolutely. Thank you.
I think we have time for maybe 1 or 2 really quick questions before we say goodbye. But I did want to ask, what is Visa's position where we have states that have lower percentages for surcharges versus what Visa's surcharge is?
Yeah, great question. So state law or local law always supersedes Visa rules. So if the state says, I think it's Colorado or New York, one of the two says 2%, then even though we say 3%, adding a surcharge of over 2% might not violate our rules, but it would violate Visa's rules. And we have a clear statement, I think it's maybe the bottom of the very first rule in the book, that says local law exceeds our law. So we will pursue those violations as a Visa rule violation, but also with the warning that you're potentially breaching state law. And I would say that A significant number of the complaints that come to us, they also write to the Better Business Bureau, they write to the state attorney, they write to the CFPB. So violating visas rules is one thing, violating local law is considerably more impactful, and you really don't want to get caught in that trap, but we will raise it if we see it.
All right. Well, it looks like we have come to the end. So, Robert, I want to thank you so much for your time today and coming and speaking with us and our clients about educating for compliant processing with visa. As a reminder, this webinar is being recorded. We will make it available to everybody at a later date. So in case you have someone that has missed it, or you want to pass it on to others that you think that this would be highly educational, we will make sure that that's done. Also, if you have any questions based on what you heard today, or your question was not asked, please feel free to reach out to your respective firm, and we will get back to you and help answer those questions for you. So Robert, again, thank you. And thank you everybody for coming today.